Please be seated. And the first case is State of Ohio versus Korey Hunter. You may begin. Excuse me. Oh, there's a. You each have 15 minutes, and the appellant may reserve up to 5 minutes, as you know. And please let me know if you wish to reserve any time.
I'd like to reserve 3 minutes. And it was my understanding the court consolidated, so this would be Korey Hunter and Vonda Hunter. Okay, so I just wanted to make sure that the record is clear on that. The state is, I'm Mary Slansky on behalf of appellee of the state of Ohio, appellant of the state of Ohio. Unusual position, at least for me. I try not to do these. In this case, Korey Hunter and Vonda Hunter both had OBI convictions that had a specification attached, and that's what we're here about. I first want to point out to the court, in case there's any confusion, Korey and Vonda Hunter are not related. One of them is African American and one of them is white, so they're not related in any way. So I don't know why the trial court consolidated, other than it's the exact same issue, same counsel, same fact pattern. So I think it was ease of disposing of 2 cases, and that's why I believe we're here on a consolidated issue today. In this case, I believe that the trial court's decision to dismiss the OBI specifications that were contained in the indictment was in error. The trial court basically said that the defendant's equal protection rights were violated. In this case, review of dismissal of charges, as the court knows, is a de novo standard of review. In this case, the defendant has not alleged, or excuse me, both of them, neither had alleged in the trial court that this involved a fundamental right or that they were members of a suspect classification. And as in State versus Hartsook, which the state cited, which is, I believe, the 12th District Court of Appeals. I'm not sure which one they all. I'm sorry. It would then be subject to whether it's rationally related to any government interest. And on that kind of rational basis scrutiny, the statute is invalid only if it bears no relation to the state's goals and no ground can be identified to can be conceived to justify the statute. In Hartsook, that was a facial challenge to Revised Code Section 2941.1413, which is the OBI, repeat OBI offender specification. There's a decision from the 8th District Court of Appeals, State versus Columbus, which is what this case is all about, and we've seen quite a few cases that have come up after the 8th District decided Columbus, basically holding that statute that I just provided for the court that gives the repeat OBI offender specification is unconstitutional. That case is currently before the Ohio Supreme Court. I believe that it's in the briefing process. I'm not sure that it's been argued yet or not, and we'll all be waiting to see what the Supreme Court does with that. But moving on with these cases, as I know we do have to do, the Hartsook in the 12th District Court of Appeals determined that the defendant's claim, because the defendant didn't claim he belonged to a suspect classification or that the specification infringed on a fundamental right, it was basically treated as a facial challenge. And I think that's what we have here, because the defendant didn't identify what type of challenge other than to say he believed it was unconstitutional because it was a violation of equal protection. The facial challenge is the most difficult for a defendant because they have to establish that there are no circumstances under which the statute would be valid. The state has no burden of proving that there's some rational basis that justifies the challenged legislation under a facial challenge to the statute. Rather, what the defendant has to do is they must negative every conceivable basis before an equal protection challenge will be upheld. And I don't believe that the defendant has done that in this case. But in the interest of, because the trial court looked at this, they basically looked at it as the court in Columbus did, which was, are there different elements between the specification and the actual underlying offense to which the specification attaches? And I believe that the trial court was in error in doing that, as I believe that the 8th District was in Columbus when they made that decision, because they took the decision in State versus Wilson from the Ohio Supreme Court and said, okay, well, in that case, the court looked at the elements and said you can't charge with a higher offense. But the distinguishing factor between Wilson and why I don't think that analysis that the Columbus court used applies here is because this is not two separate offenses that we're comparing to say, you know, can we charge with the aggravated robbery or the robbery? You know, this is a specification that attaches to the underlying charge, and it's not really a separate offense because you can't have a standalone specification that would not be a valid charge that the state could bring. It has to be attached to some underlying offense, and in this case, it would be the actual OVI offenses that are chargeable under the A1 and the A2 section of the statute. So there were two specifications, but it was basically the same. It was one set of circumstances in each case. The specification only applies in three circumstances. One, if the offender has 3 or 4 prior OVIs within the previous 6 years. 2, if the offender had 5 or more OVIs within the past 20 years. And in the third instance, if the offender had a felony OVI at any prior time. So that's the only circumstances under which the specification would apply. And in this case, I believe that the state has a rational basis, the legislature, there's a rational basis for them to treat a repeat OVI offender to subject them to a greater punishment in this case. And I think that there's no equal protection violation in this case. One, because the defendant hasn't satisfied his burdens in this case to show that there's no circumstances under which the statute could be applied constitutionally. The second issue I wanted to bring to the court's attention is the state's argument that, or I should say that the defense argues in their brief that almost like I'm trying to think how to put it, that there's a violation because a violation of their equal protection rights because it's up to the prosecutor to use their discretion and to decide what charges to bring. Well, that's how the criminal justice system works. The prosecutor has basically unfettered discretion to decide what charges to bring, as long as they're not violating someone's rights in doing that. And this defendant hasn't shown, neither of these defendants made any effort to show to the trial court that there were other individuals who were treated disparately or differently than they were treated under the statute. And so it comes down to a discretion. You know, they haven't alleged that the state is impermissibly putting this charge on them when not putting that charge on other people that are similarly situated. And I would just note for the court, and I know the state's reputation is the court's probably aware of it, we tested OVI specification to every offense to which it would apply. It's not something where the state comes in and says, you know, I'm going to decide to apply it only to people that have no children, you know, or people that do have children. I mean, there's been no showing that there was some disparate treatment by the state between similarly situated offenders. And in fact, this case is a classic example. Two unrelated people, same facts, you know, they both have OVI charges and they both get the specification. And, you know, they have the prior convictions to support that. And the state applied it equally to everyone, and as the state does. I don't believe that the trial court was correct in applying Columbus in this case. I think the Supreme Court is eventually going to weigh in on this, but in the interim, I would ask that this court find that the trial court erred, one, in determining that the OVI specification violated the equal protection, 2, that there was some kind of disparate treatment by the state, or that the state had the ability to treat people disparately, and 3, that this notion of the elements of the offense analysis.
Well, I'm interested in something that you just said, and that is that the state has treated individuals disparately or has the ability to. Is it sufficient for the appellant, for the appellee to argue that the state has the ability to treat?
I don't believe that that's correct. I think that in this case, because they're making this facial challenge, they have to show that there's no circumstance under which that specification can be applied equally to everyone. And they didn't do that in this case. And so when you look at it as a facial challenge, as the court did in Hertzog, the defendant in no way has met their burden in this case, and the state wasn't required to show that the, I lost my train of thought, I apologize.
You've almost hit your 5 minutes as well.
But I would ask that this court overrule the decision of the trial court and find that there was no equal protection violation and that RC 2941.1413 is constitutional both under the facial challenge and as applied in this case. Thank you.
Thank you.
Attorney Matthew Borowski on behalf of the attorneys Korey Hunter and Vonda Hunter. I'm here on behalf of Attorney Duff, who is the counsel of record at the trial level. Just a word on...
I'm sorry, what did you say your name is?
Borowski, B-O-B-R-O-W-S-K-I.
Thank you.
Just a word on why they were, these two cases were connected. We were counsel for both parties, and the briefs, both actually by the state and by us, were written essentially with identical language except for changing gender pronouns and changing the facts of the underlying indictments, but everything else was identical. So we said because of the complete concurrence of all the legal issues, they were joined at this level.
You know, before you begin your argument, let me just ask you something a question based on what Ms. Lanska said just as she sat down. She referenced the fact that these are two completely unrelated individuals. And, I mean, not blood related or related in any other way, but they both have the same charges, and they both were given the specs. So doesn't that cut against your argument?
I think it can. I also think, though, I think the issue here is not the fact that they both have the same specs. It is more the potentiality for disparate treatment is the issue. Is that as the state has treated it, they have the discretion to impose or withhold the spec. The problem is that there should not be any uniformity in the imposition of the specification. If there's no uniformity, that is where the protection issue ultimately would arise. Because you would have.
But you said could arise, so doesn't that suggest that there's not really a case or controversy?
Yes, there is that issue. Certainly, in both of these cases, there was uniformity. However, position in Columbus and ultimately our position we have taken as well is that the issue becomes the potentiality. Ultimately, and the state to touch on this, the issue, the way we view it is that the equal protection issue is that the state can increase the penalty for an underlying offense without having to produce any additional evidence, elicit any additional testimony, produce any additional exhibits, nor does the finder of fact have to find any additional facts ultimately. The only condition for the additional punishment is the imposition of a specification in the indictment. And we agree that under this equal protection argument we're making, it would have to be a rational basis review. And we believe, however, that Columbus Court was correct in using Wilson, and that it has to think more about this as the statutory scheme. When you have two different applications of the criminal law that can result in different penalties, but you have the same underlying set of facts, there can be an equal protection issue there. The test should actually be, from our view, is that if there's an elevated crime, does the state have the burden of producing proving some additional element beyond that's required for the lesser offense. If the statutes prohibit identical activity, require identical proof, and yet impose different penalties, the person under the statute with a higher penalty has suffered an equal protection violation. I think this goes to a certain degree, does go back to the issue of prosecutorial discretion. In this instance, the OVI specification actually does not allow the state to actually kind of predetermine the ultimate criminal penalties. If there is no OVI specification imposed, the defendants could face as little as 60 days in jail and no more than 32 months in prison. However, once the OVI specification is imposed, that option is foreclosed upon. The judge and judiciary no longer have the ability to go with the lesser penalty. They have to impose a penalty of at least 14 months in prison and up to 7.5 years.
So, I don't believe that this is in the record, but the prosecutor has just indicated that the state charges everybody who qualifies with the spec.
Yes.
So, understanding that we won't consider that if it's not in the record, would you not have been on more firm footing to be able to perhaps anticipate, I don't know if you could have anticipated, but to come in and show, you know, here's this case where the spec was applied, and here's a case identical where it wasn't.
I completely agree that you would have certainly been on more firm footing.
Yeah.
However, we were not able to find anything that met the criteria where we were not going to move outside of the basic fact pattern far enough where we would have issues there. Ultimately, a lot of the 11th and 12th districts have, more so the 12th, has taken issue with Columbus as an attack on prosecutorial discretion. And I think that there is merit in that argument. However, I go back to what I was just talking about. It's not so much the fact that we're going against prosecutorial discretion here. It is more so the fact that the prosecutor is able to predetermine the penalty with the imposition of the spec. The spec, if the trial court had the option of being able to use the lesser included charge and use the lesser penalty, that would be, the possibility of disparate treatment would be lessened. However, because in this situation, what you would have is, you can have a person with the spec imposed, then they have to get the higher penalty. But a person without the spec, with the same underlying elements, would be eligible for the lesser penalty. Ultimately, the issue becomes that because there's no requirement of uniformity application in 29, 41, 14, 13, there's no rational basis for the imposition of that penalty. And it's simply, it's ultimately arbitrary. And for that reason, we believe that Columbus was rightly decided, despite the fact that it does have some issues in how it was argued. That's all I have to really say. It's joined there.
You still have 6+ minutes.
I
wish to use them. Once you step away, I'm afraid they are gone.
I realize that, and I didn't expect to get through all my notes quite that quickly. But, the one point I didn't make, and I think I can touch on, is we're also not disputing that cumulative punishments, as opposed to like gun specs and things, are valid. What we're saying here is that ultimately, the when the courts have examined this spec in particular, under 29, 41, 14, 13, they have examined it under a double jeopardy analysis, and we are making, and Columbus made, an equal protection analysis of this. And just because it has been found to be constitutional under a double jeopardy analysis does not foreclose upon it having equal protection issues. And for that reason, just because it's a cumulative punishment punishments have been found to be valid under double jeopardy, does not necessarily follow that it's going to be so under protection. And actually, that is the end of my notes. So, nothing further?
Thank you.
Thank you very much.
Your Honors, I think we'll be further ahead of schedule. I really just wanted to clear up one thing. Judge Moore, you're correct that it's not in the record what the state's history of charging things is. But the reason that there's nothing in the record about that is because the defendant failed in his burden to prove that there was some disparate treatment, and that's their reasoning. And I would submit to the court that in the absence of proof, the court has to accept that everyone must be treated equally because they haven't shown that they weren't. So I think it's the absence of something in the record in this case that the court considers as proof of what's done in the OBI cases in Lorain County with regard to the specification. So I just wanted to clear that up because it was on a facial challenge such as this, and it was the defendant's burden to show that in the disparate treatment argument that there has been some disparate treatment. It's not the potential for, it's the fact that actually a prosecutor in exercising their discretion is violating someone's rights because they're exercising it in a manner that is treating similarly situated people differently. And the defendant has the burden to show that, and they didn't meet that burden in this case. I would submit that the trial court...
Let me just follow that up. We're just talking about the law because, of course, on appeal, the appellant has the burden of presenting the record. But below, once the defendant raised the issue of disparate treatment, it seems that there was probably nothing to prevent the state from submitting by way of an affidavit, say from the prosecutor, that a statement that said every single case that comes in this county that is eligible for the OBI spec is charged. Would that have put it squarely before this court on appeal?
I think it's squarely before the court because what the law is, and the court has the de novo standard of review is, the defendant filed a motion, they were challenging the statute, they had the burden of showing that there was some disparate treatment, and absent that showing by them, the state didn't have any burden to respond or to put anything on the record with regard to that. And I think that in doing that, it kind of could have undercut our argument that they failed to demonstrate what they were required to do in this case. So, there are no other questions?
Thank you. I take the case under advisement, and as always, send you a copy of the written decision that is issued, and you can check the webpage if you want to get accelerated evidence. Thank you, and have a good day.